Test.
Hey, Madam Attorney?
Yes, sir.
Yeah, so Cheryl is stapling as we speak, and we'll get started.
Okay. Hope everyone, Mr. City Manager and members of council, hope everyone is doing well this evening.
All is well, thank you, ma'am.
Test. Test. All right, good evening again, everybody.
Good evening.
The day is Wednesday, May 15th, 2024. We're here in the City of Manila Council Chambers, better known as the Honorable Mayor Joe Hayward Council Chambers. This is a called meeting. This meeting was called by the mayor. And at this time, I'd like to ask our city clerk, assistant city manager, Cheryl Ford, to call the roll, please.
Councilman Barley,
Here.
Councilman Morgan,
Here.
Councilman Collins,
Here.
Councilman Pollard,
Oh, here.
Councilman Plum.
Here. All right, thank you, Cheryl, thank you, council. At this time, I turn to our city manager, lead in prayer, please.
My pleasure, Mr. Mayor. Dear Lord, God, we thank you so much for this day that you woke us up this morning, Lord, and you woke us in our right mind. Now, Lord, I ask that you give these men clarity of thought tonight as they discuss the business at hand. God, we thank you for their presence in their service. In Jesus' mighty name, I do pray. Amen.
Amen.
To the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right, thank you, city manager.
Yes, sir.
Thank you, everybody, for the pledge. At this time, council, is there a motion to approve the agenda for today? Motion. Second. Motion properly second, any discussion? All right. All in favor? All opposed? Motion carries. Thank you, council. At this time, are there any speaker appearances? All right, hearing none. We'll move on to the action item for today, which is City of Manila Council Structure and Representation. And council germane to, or related to rather, this item, and to get the brief from the city attorney to discuss this. At this time, council, I'm asking for a motion to waive the city's privilege so that the city attorney can share this obviously with us and share it publicly. Is there a motion?
Motion to approve. Second.
Motion properly second. Any discussion? All right, so what I want to just echo to the community before we get started and before the city attorney gets started. I want to, regardless of the legal entanglements, if you will, here in the city, I want to remind everybody that in addition to this council, the city council had the foresight to create a urban redevelopment agency, the URA. And basically what that means is the majority of the city, if not all of it, falls under the URA. So whereas I am confident that we will continue to do business here on this council, just be rest assured that the URA, which has 3 members on it, which I chair, the business of this city does not stop. So either it's here or is it the URA? Either way, I want everybody to understand the business of Camilla and the continuation of everything we've done. Let me stress that everything that we've done will continue as we make our way through the legal nuances, if you will. So at this time, Madam Attorney, hold on one second. All right, we have a motion. Any other discussion? All right, we have a motion to properly second. All in favor? All opposed? Motion carries. All right, thank you, council. Madam Attorney, at this time, we'll turn it over to you. Please know that privilege has been waived by this council, and the floor is yours.
Thank you, Mr. Mayor, members of council, Mr. City Manager, and Madam Clerk. I will go through, some of this will sound familiar to you and the citizens of our great city, and I will go through the memo. I will ask that following this meeting, since the motion to waive the privilege has been made, that you will allow not distribute what you have in your hands to the public, but I will send an email to each of you with the appropriate notation that privilege was waived, appropriate watermark noted thereon, so that that can be the document that you can distribute for public dissemination as you deem fit. So I just want to talk about a little bit about what brings us here today and why the mayor called today's special call meeting concerning the important matter involving the composition and structure of the city government. On yesterday, May 14, 2024, the Georgia Supreme Court issued 3 decisions involving pending appeals involving the city of Camilla. Those 3 cases were: 1, a quo warranto civil action concerning council member Corey Morgan. 2, a quo warranto civil action involving council member Tara Pollard. And 3, a civil/criminal contempt action involving council members Corey Morgan and Tara Pollard. The city of Camilla appeared as an intervener in this matter at the trial court level and filed an amicus brief in this contempt action that was pending in the appellate courts. Each of these 3 cases involve the same party plaintiffs, David Cooper and Joe Boston. As I indicated on yesterday, May 14th, 2024, the Georgia Supreme Court issued a decision without opinion in each case. As a result, the previously issued written decision that was rendered by the Georgia Court of Appeals on December 21st, 2023, remains unaltered. As of today's date, neither of these decisions are final until such time as remediator is submitted to the Mitchell County Superior Court by the Georgia Supreme Court. And if you would indulge me, and for members of the public who may not have refreshing in their memories, I'd like to just run down some of the essential facts that underlie each of these three cases. So November 26th,
Madam
2022,
Madam
David
Attorney,
Cooper and Joe
you're,
Bostic filed a petition for quo warranto in the Superior Court of Mitchell County, challenging the residents. Can you hear me?
yeah, so you're going in and out a little bit.
Okay, here's what I'm going to do. I have been, I was on my laptop, and maybe I need to change to my desktop. Will that be helpful?
Yeah, let's see.
I want this is important. Do you want me to,
Yeah, let's give that a shot. Yes, ma'am.
give me, just give me 1 second. I'll take this. Mayor and Council, is that better?
Yes, absolutely.
Okay. Thank you. My apologies. Would you like for me to begin again?
Yeah, maybe that's not better.
A lot of feedback.
There's a lot of feedback coming back.
Hold on 1 second. I know what that is. Okay, did that resolve it?
Yes, let's go ahead and give that a shot.
I was watching, I had the live stream on, so I had to disconnect from the live stream. My apologies for my lack of technical status. Shall I begin again, or?
Yeah, at November.
Okay, so again, I will give a brief, factual summary, some of which you have heard in the past from me, but I think it's important to give context to where we are today. So November 22nd, 2022, David Cooper and Joe Bostic filed a petition for quo warranto in the Superior Court of Mitchell County, challenging the residency of council members Morgan and Pollard. The petitioners alleged that neither Morgan nor Pollard were qualified to serve on city council because neither resided within the city limits of Camilla as required by city charter. Under Georgia law, if a quo warranto defendant filed an answer under oath denying the allegations asserted in the quo warranto petition, the trial court is mandated by law to convene a jury of 12 impartial jurors to determine whether the allegations are true. Messrs. Morgan and Pollard filed a timely answer under oath denying the allegations asserted by petitioners Cooper and Bostic. As a result, the Mitchell County Superior Court issued jury summonses to Camilla citizens for the purpose of determining whether the allegations in the petition were true. The jury trial was scheduled to take place on July 17, 2023. On that date, July 17, 2023, those same summoned citizens appeared for jury service for the purpose of rendering a decision in the quo warranto proceedings. However, prior to seating a jury of 12, the Superior Court judge entertained a motion filed on behalf of the petitioner. That motion alleged that council members Morgan and Pollard had not answered deposition questions in a satisfactory manner. After hearing that motion, the court announced verbally that it would penalize Mr. Morgan and Pollard by striking their previously filed answers and summarily enter judgment in favor of the petition. As a result of the court's announcement, Those citizens who have been summoned to serve as potential jurors in the Warrenton proceeding were sent home and no jury trial was ever held. And in other words, there was never an adjudication on the merits of the allegations in the petition rendered, filed by the petitioner. 3 days later, on July 2023, the trial court issued a written order and final judgment, declaring by way of default judgment that Morgan and Collins did not reside within the city limits of Camilla. The quo warranto order, though signed by the trial judge, was principally authored by counsel for petitioners Bostic and Cooper. On the following day, July 21st, 2023, Messrs. Morgan and Pollard each filed a timely appeal of the quo warranto default judgment order. They paid assessed costs to the Mitchell County Superior Court clerk. Under Georgia law, the filing of the appeal notice and payment of the costs stayed the enforcement of the quo warranto order. In other words, supersedious was in effect, and the stewards Morgan and Pollard could continue to lawfully serve on city council during the pendency of their respective appeals of that quo warranto order. Notwithstanding supersedious, on August 1st, 2023, the petitioners, Bostic and Cooper, filed a civil contempt motion in Mitchell County Superior Court, asking the trial court to find Morgan and Pollard in contempt on more than 40 counts each of alleged misconduct. Each count of alleged misconduct pertaining to Messrs. Morgan and Pollard's continued service and official action as council members during the pendency of their appeal. Petitioners Bostic and Cooper requested that the trial court not only imprison Morgan and Pollard for 50 days, they also requested the trial court impose more than $100,000 in monetary fines against each of them. On September 1st, 2023, the trial court convened a hearing to consider the motion for contempt. As authorized by mayor and council, this office, the office of the city attorney, filed a motion to intervene in the contempt proceedings because each of the acts alleged in the motion for contempt concerned Messrs. Pollard and Morgan's official service as council members for the city of Camilla. After oral argument, the trial court announced from the bench that the motion for contempt would be denied because the trial court was without jurisdiction to find either gentleman in contempt of court due to supersedious. Again, the trial court determined that it would not impose the requested act of imprisonment or assessment of $100,000 in monetary fines against either Morgan or Pollard due to the fact that supersedious was in effect. On September 15, 2023, petitioners Bostic and Cooper appealed the trial court's denial of their motion for civil contempt. They found that appeal to the Georgia Court of Appeals. And on December 21st, 2023, in a combined opinion, meaning that the Court of Appeals combined each of the 3 cases that I referenced at the start of this discussion, in a combined opinion, the Georgia Court of Appeals affirmed the trial court's order declining to find Morgan and Pollard in contempt of court because supersedious attached to that July 20th quo warranto order. The Georgia Court of Appeals also affirmed the trial court's July 20th quo warranto order removing Messrs. Morgan and Pollard from office, and that specifically determined that supersedeas will continue to be in effect as long as that order remains under appeal.
Excuse me, Madam Attorney, before you go into your legal analysis, so that we're clear and the record's clear. As of today, the question of whether or not Councilman Pollard and Councilman Morgan are or were residents of the city of Camilla, that question has never been answered. Is that right?
That question has never been adjudicated on the merits, and that is correct, Mr. Mayor. The default judgment that was entered based upon an alleged discovery violation interrupted the jury trial that was scheduled to be held and to commence on July 17th, 2023. So there has never been, and as the trial court, Judge McCourty stated back in September of 2023, he specifically noted, for those who were in attendance, he specifically said, this issue of residency has never been adjudicated on the merits.
So this, while we're here today, is due to a technicality, if you will, or answers that Councilman Morgan and Pollard gave in the deposition, and the judge deemed that conduct, if you will, during that period was unsatisfactory, thus removing it from office because of the alleged conduct that was perceived, if you will, during that deposition and other discovery deals. Is that right?
That is correct. The order, the July 24th warrant order, was based in the entry of the law, was based solely and exclusively on the allegations of dealing with the questions as responded to by Mr. Morgan and Mr. Pollard.
Okay. Thank you, ma'am.
So following the Georgia Court of Appeals December 21st, 2023 opinion, appeals continue to the Georgia Supreme Court. So petitioners Cooper and Bostic appealed the civil contempt ruling, and that supersedeas applied and prohibited them from imprisoning and or getting $100,000 in monetary fines against each Morgan and Pollard. Secondly, council members Morgan and Pollard each filed an appeal to the Georgia Supreme Court, challenging the Georgia Court of Appeals upholding the decision to remove them from office based upon that July 20th order that arose from a default judgment. I want to talk a little bit about what happened. So yesterday, the Georgia Supreme Court issued decisions that concerning each of those appeals that were pending before it. So I want to talk about the civil, I want to talk about the civil contempt proceeding appeal. And that was not mentioned. I noticed I read it in the local newspaper, but that issue, that decision was not mentioned in the local newspaper in your greater city. So the Georgia Supreme Court's decision on yesterday confirmed that Councilman Morgan and Pollard acted lawfully while continuing to serve the dependency of their respective appeals. The Georgia Supreme Court's May 14, 2024 decision now unquestionably has determined that these individuals did not act in willful contempt of the court's orders removing them from office because of the supersedeas that allowed them to continue to lawfully serve as city council members during the pendency of the appeal. In sum, the trial court was correct in declining to find Mr. Morgan and Pollard in civil or criminal contempt. until such time as remittance is issued to the Mitchell County Superior Court, supersedeas will remain in effect. Now, I want to talk about, Councilman Morgan and the impact that the decision has with respect to, his current term of office. So the decision, the July 20th Paul Warrenton decision that was issued by the trial court, the petition that, for Paul Warrenton that was filed on November 22nd, 2022, has no applicability to Councilman Morgan's current term of office that began on January 1, 2024. So as we know that on November 7th, 2023, Mr. Morgan was elected to a new term of office effective January 1, 2024. And prior to Mr. Morgan, Councilman Morgan, being elected to office, if you will refer to footnote 5, Mr. Morgan was subject to a residency challenge by his opponent, Ginger Kemp. Upon qualifying for this new term of office, a challenge was filed in the election to the election superintendent, alleging that Mr. Morgan did not reside within the city of Manila and was not eligible to run for elected office. An administrative hearing was held, and the election superintendent ruled that Mr. Morgan was in fact legally qualified to hold office, seek office in Camilla, because he did in fact reside in the city of Camilla. Ms. Kimmel, through her counsel, filed an appeal of the election superintendent's decision to the Mitchell County Superior Court. The Mitchell County Superior Court judge upheld the election superintendent's ruling and determination that Corey Morgan resided within the city of Camilla and could lawfully seek elected office in the city of Camilla. Now, there is no provision in Georgia law that allows a quo warranto order to exist in perpetuity and forever follow an individual in every subsequent political endeavor. Here, Mr. Morgan was duly elected to a new term of office effective January 1, 2024. And as I stated earlier, the July 20th quo warranto order is of no force and effect to this new term of office. And at that, I will end here, Mr. Mayor and members of council, and answer any questions that you may have.
Yes, sir.
Yeah, I think I would just like for the city attorney to touch on the fact that Ms. Kimmel also sent that to the Georgia Supreme Court too, and I think she didn't recap.
Thank you. That particular, thank you, Councilman Morgan. That particular challenge that Ms. Kimmel alleged concerning challenging their current term of office was passed upon by the Georgia Supreme Court, and the case was dismissed. The Kimmel appeals were unsuccessful. So as a matter of law, that issue of Mr. Morgan's residency and or qualification to hold legal office for his new term cannot be relitigated in any court of law.
All right, so Madam Attorney, I'm just gonna ask you a couple of questions to kind of put this in a bow, if you will, for folks that are here in the gallery and for the folks that may be listening online. As you noted, there is a so-called newspaper in this region that has a terrible habit of leaving stuff out. So that we're clear, if a remittitor is sent back to the city of Camilla based on these rulings at the Supreme Court, what effect will that have on Councilman Morgan?
It is my opinion, my legal opinion, that act will have no impact, no legal effect on Councilman Morgan's current term of office that began on January 1, 2024. The previous quote warrant of petition dealt with Councilman Morgan's term of office, previous term of office. That office had expired, that term of office had expired, and you cannot, and that quote warrant order cannot be brought forward into this new term of office.
All right, and the second question, and you touched on this a moment ago, relating to supersedes, that, again, I concur that there was a so-called paper here regionally that reported on the results from the Supreme Court yesterday, but as you mentioned, an important piece of that was not, this public was not informed on if they purchase this, So, is it my understanding that up until today, and through today, if you will, Councilman Morgan and Councilman Pollard, based on that third decision by the Supreme Court yesterday, that they had been serving lawfully throughout this entire process?
Yes, sir, and I will add up, not only up until today, up until the time that Mr. Ford is issued under the prior term of office, these gentlemen have been acting lawfully. They have lawfully served. They have not acted in contempt. They acted pursuant to the law that afforded them the right to have the enforcement of that July 20th home warrant order based upon a default judgment. They had the right, according under Georgia law, to avail themselves of the supersedious that allowed that order to be stayed in place and unenforceable until such time as a remittance is issued resolving the case, these appeals in full and final manner. So nothing, and I think I want to stress that, I think that was an important element of the public reporting that was omitted because having been present at the hearing on the motion for contempt, having been allowed to present arguments to the court, the trial court at that time, I recall the allegations and assertions of illegality, not being lawful in their actions and their official actions. And I think it's important for the citizens to note that this office advised the mayor and council that supersedes was in effect immediately upon the filing of notice of appeal and payment of costs, and the Georgia Supreme Court's decision just confirmed that fact. And again, as you stated before, Mr. Mayor, this was a historical decision.
Okay. My final question for you, Madam Attorney, as it relates to Councilman Pollard. Obviously, this decision was rendered yesterday, but so that folks that may be wondering, if you will, and I think you touched on this, I just want to speak it plain, if you will, that until the remittitor is sent to the Superior Court here in Mitchell County, is it fair to say or legal to say that Councilman Pollard is still serving as a council member legally and lawfully?
Yes, sir.
All right. All right, Council, I yield for if there's any other questions. All right. Madam Attorney, do you have anything else for us?
No, sir, I do not.
Okay. All right. And again, everybody, just as a footnote, there's a lot happening You know, no one knows what tomorrow or next week or next month will bring. But I want everybody to understand that as of today, what you're seeing up here right now is the status quo. That this is your city council. Until such time, as the city attorney mentioned, a remediator is sent back down here to Mitchell County Superior Court. And if and when that happens, as I mentioned at the top of this, please know that either way, we're going to continue to do business here in this city. All right. So, all right, council. Any other statements for the for city attorney? All right, council. It appears that we've reached the end of our agenda. Is there a motion to adjourn? Motion. We are adjourned. Thank you, everybody. Thank you, Madam Attorney.
Thank you, sir.
All right.